Welcome to Off the Record, a legal podcast.
Welcome back to Off the Record. Today, we are joined by Leslie Fisk, an experienced family law attorney and mediator serving families in the upstate South Carolina. Since 2007, Leslie has represented clients through some of life's most challenging moments with deep experience in custody, support, domestic violence, and divorce matters. I'm Leanne Lyon, and today we're talking about child support and common questions people have about child support. Leslie will explain how South Carolina courts handle child support and what real options you have. Hello, Leslie.
Hello, good morning.
Good morning. Before we begin, can you give me a little background? How do you get involved, or why did this become your specialty?
Oh, thank you so much for asking. Well, family law interested me the most because my parents had a really contentious divorce. And I grew up knowing kind of that tension that often children have when they go back and forth from one parent to the other, and also wanting to spend time with both parents, maybe missing the other parent and just feeling a little torn between them. I was a child who really felt a lot of their emotions very deeply. And so I wanted to help future families to try to have a more amicable divorces or separations so that it would be better for the children going forward. So that's what first interested me in this kind of work. Then after I was in law school, I also discovered public interest and really began to become interested in helping survivors of domestic violence, abuse, manipulation. And so I've done both of those in my career. I've both helped people come to amicable resolutions. And on the other hand, sometimes I have to fight and be much more aggressive to make sure that justice is done.
Wow, that's a very touching story. Thank you for sharing that. Also, there are so many questions around child support. I mean, people have 1,000 questions. So maybe they're even asking these questions before they actually get to the point of divorce. Is that common?
Absolutely, yes. Sometimes when couples are arguing, that's one of their first questions is, what is the money going to look like if we end this relationship?
Sure. So is there a way for them to figure that out? How is it calculated?
So in South Carolina, there are several factors that do go into it. The primary factors are the incomes of both parties. And when I talk about incomes, I'm talking about gross income. So incomes before taxes and other deductions are made. That can also include overtime, or somebody has a second job. We include that information as well. If somebody receives benefits, such as VA benefits, those will be counted. There are a few exceptions, but generally we're talking about, we look at all the income they have coming in before deductions are made. So that's the first consideration. After that, we look at how many children under the age of 18. I say under the age of 18, but it can also include someone who is 18 and finishing up high school. But generally, we're talking about young children before they reach 18. Then we look at other expenses that these children have, primarily daycare costs, health insurance costs. And then there are a few children who have extraordinary medical costs. For example, if you had a child who needed a very specific type of therapy, and let's say that therapy costs $600 a month, that cost could also be considered when the calculation is made. If somebody wanted to get a rough estimate, they could go, you could Google DSS South Carolina child support calculator. It's not 100% perfect. There could be exceptions, but it can give you a rough idea to start with.
You mentioned that, 18-year-old is kind of the cutoff for child support, and yet also mentioned sometimes you have an 18-year-old who's still in the care of the parent, though they finish high school. I would imagine some people think, well, when they turn 18, I don't have to pay child support anymore. Can you address that?
Sure. So the cutoff is generally 18, or if they're still in school, when they turn 19 or when they finish, whichever one comes first. So if a child turned 19 in April of their graduating year, then it would cut off then. But if not, then it would go to the end of their senior year, and that's when it would stop. If they didn't go to school, if they were in school at the time, then it would cut off when they turned 18.
Okay, and it kind of a similar question. If you have two children, one turns 18, does it automatically does it just go right into one half?
Common misconception, and the answer is no. There has to be another calculation done. And the way the calculator works is generally when you rerun the numbers with one child instead of two, it is a smaller number, but it's not exactly half. So I do recommend that people not just assume that it will be half. Another problem that comes up often that I recommend is that when your child does graduate from high school or turns 18, don't forget to do the paperwork to make sure that that child support obligation stops. Many times, if the parents are getting along all right and everyone agrees that child support stops, it's not a problem. But there are many situations where the parents aren't getting along. One person wants it to stop and assumes the other person will cooperate. The other person doesn't cooperate, and it can create some nightmare with the paperwork.
I can imagine that would be so. I mean, unfortunately, divorce is never easy, and the emotions run high and all the things. And you've been through it, so you personally know. So as the children get older, is it recalculated frequently?
Great question. It's not automatically recalculated, but either party can ask for a recalculation. If I'm representing the person who is paying child support and they come to me and said, I think the other parent is earning more money, I want to recalculate. Many times I will ask if they have any idea, an estimation of what that other person is making, and then also ask my client if their income has increased. So then we'll run the numbers to get a rough idea, even if we don't know exactly what the other parent is making, before we bring a court case. Because what you don't want to do is bring a court case, find out the other parent really isn't making much more, but your client is, and now they're paying more than they intended to. So also another way we often handle it is send a letter to the other parent saying, we believe income has changed. Will you please cooperate with us, provide these numbers so that we can work it out? Generally, the calculation is pretty black and white. There's not a whole lot of arguing. So it is what it is. And so for that reason, many people who've been through previous custody and divorce situations realize that often it makes more sense to cooperate, share the numbers, so that the child support can be calculated.
So here's another question. Is child support always a factor?
Almost always. I have a lot of clients who say, why do I have to pay child support? Why don't we just take care of the children when each parent is with the children? But the law right now supports child support, and I believe it will continue doing so. So unless the parties have an agreement, child support is going to be ordered. Now, parties can always agree differently, whether it comes to the children's schedules, decision-making, financial. Courts love it when parties work together and come up with their own agreement because generally those parents know best what works for their kids and for their own situations. But if we don't have an agreement, there's going to be child support. And, people sometimes argue about that or complain about that, but that's just what it is. And also, lawyers know that their clients, that there will be child support. So if the parties have attorneys, most attorneys will recommend that their client do consider child support, whether they're the ones paying or they're the ones receiving, because we know the alternative is going to court and we know the judge will order child support.
Can you give an example of somebody who maybe came and said, look, I have kids half the time. I don't have to pay child support. How did that work out for them?
This comes up very frequently. And so what we do is we'll run the numbers, and there is a way you can calculate child support on what we call the C guidelines. A is the standard. There's a C calculation option when there is more shared parenting time, and it's not as much of a standard where the children are with one parent primarily and visit the other one generally every other weekend or so. So when it's more of a shared parenting situation, that does affect the numbers. It takes a little more into account that there are more evenings or more nights spent with that visiting parent, as we often refer to them. And so that does adjust the numbers. Generally, they're still child support. And so we'll run that number, see what that number is. And if it turns out to be a very small amount, let's say $50 a month, then it's much more likely the parents are going to agree to something different, such as instead of, I'm just going to throw an idea out here, instead of paying child support, this parent is going to pay the first $50 of soccer fees every month or something like that. People can be a little bit creative, but knowing what that number is and what the law would support is the first step in figuring out what a reasonable settlement would be. So even though many cases eventually end up in a settlement, that number, that calculation turns out to be really important, whether you let a judge decide or whether the parties agree.
I'm really glad you brought up soccer, because as the mother of a student athlete, I know how expensive sports can get. Is extracurricular calculated into child support?
It is in some states that is considered, but not in South Carolina. So in South Carolina, the person who is receiving child support is the one responsible for extracurricular expenses unless the parties agree otherwise. So if in a family where sports have always been important, the parents often agree, we want our child to continue in this sport. And especially if it is a very expensive sport, one parent alone may not be able to afford that price. So it is common that parents agree, in some cases, to divide extracurricular activities. I have seen in the 18 years I've been doing this, maybe one or two times that the judge did or the payor of child support, the one paying child support, to contribute a bit. But we have to make a pretty solid case that this sport or extracurricular activity is key to this child. Most of the time, the court does not make anyone do extracurricular activities, either parent. And the reasoning is that it is not a necessity. It's not like food or water. You don't have to have an extracurricular. It is a bonus if you have it.
Absolutely got that.
And one thing to consider too is these laws and family courts apply to people from all different income levels. And so the laws have to apply for people who are making minimum wage or receiving benefits to the people making $200,000 a year. And those are often different lifestyle choices, but the laws try to sort of meet in the middle and do the best they can, but they're certainly not perfect for every situation. And that's also why anytime we can get the parents to come to an agreement that they know is best for the child, that is ideal.
So that brings up a great question as well. So you have an agreement, you're moving along, and then what happens if one parent or the other loses their job? That's got to be a very different situation depending on which person it loses their job as well.
Absolutely. And so if the person who was paying child support loses their job and they come to me and say, I lost my job, I can't afford this child support anymore, my first two questions are, tell me why you lost the job. And second, what have you done to try to find another job? So if they lost the job because of talking back to the boss or being drunk at work or something that's considered a fault, it's going to be really hard to convince the judge that we need to drop child support, lower child support based on that. But if it was a layoff that they had no control over, generally the courts will be a little bit more lenient, but their next question as well will be, what have you done to find another job? And so if someone was making, let's say, $70,000 a year, they had a layoff, had nothing to do with them, and then they found a job that was $63,000 a year. That's pretty close. And generally the courts would agree to adjust the child support accordingly during that time. But if that person said all they could come up with was a minimum wage job, which in South Carolina right now it's $7.25 is minimum wage, that's $12.56 a month, then that's a huge difference. That's a huge drop in their income. And so in that case, I think it would be a harder road unless we could show that they've tried everything else, and this really was the only job available to them at the time. So that's where the lawyering comes in to prove the everything this person has tried to do, and maybe try to encourage my client to get extra education or touch up on skills if needed to try to get closer to that original income that he or she had.
Well, with a touch of sarcasm, I will say, of course, everybody acts in the best interest of everybody and has complete integrity. So I'm sure this doesn't happen. But what if, the payer accuses the recipient of using the money on herself, doing her nails, getting her hair done, going out? I don't know. What happens then? Is that possible?
Comes up all the time in my job. So the way that the law and the judges look at child support is that if these parties were still together in a family, both parties would be contributing some effort and finances to the raising of these children and the well-being of these children. And so just because they are separate doesn't mean that each party should not still contribute financially to the well-being of these children. And the well-being, what I mean by that is when you have two incomes, generally you can have a nicer place you rent or a nicer place you buy. More people, including children in the house, means higher electricity bills, higher water bills. Maybe instead of basic cable, they have Netflix, and there's extra expenses of having a child. And so the judges and the courts are not going to make that parent receiving the income prove how they're spending that income. They could spend it on Netflix and having a nicer home and maybe occasionally going on vacation, because the courts consider that generally is better for the child to have this better lifestyle than they would have had otherwise. But it certainly does frustrate my clients when they're the ones paying, if they see signs of the person receiving the money, their lifestyle going up, but don't see how it impacts the children. So there's not a way to force that person receiving child support to prove how they are spending the child support.
Well, there is the phrase, happy spouse, happy house. But if they're no longer a spouse, I can understand that would be a challenge. Any last things you'd like to add as we wrap up our show today?
I think generally the best outcomes regarding support are if both parents go into a relationship which is separating, people are separating, and think we want to keep the effect on our children as minimal as possible. And what do we need to do to make that happen? Does that mean both financially and in other ways as well? Does that mean we need grandparents to help out more or other family or friends? Does it mean we need different daycare options, babysitter options? Can we keep this child in the supports or art or theater that mean a lot to this child? Anything you can do to kind of minimize the disruption of the child's life is ideal. And so I strongly recommend that people, even if they don't like how the law reads right now regarding child support, that they do consider all of the money they've always spent on their children, and that even if it looks different, how that money is spent is still very important to the well-being of the child and the outcome of this child and how this child deals with their parents not being together anymore.
Well, thank you so much. And that's it for today's episode of Off the Record with Leslie Fisk. To learn more, visit retbernie.com, and thanks for listening. Remember to like, subscribe, leave a review, and most important, share this episode if you found this helpful. Thank you.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.